Welcome to this CPD presentation by the Estate Agency Affairs Board. Today it's my pleasure to talk to you about the conveyancing procedure and the things that go on in a conveyancing office that some of you are probably not aware of. We all treat our conveyancers with the utmost respect, and you're going to find out now why we do so and the role that they perform, which I'm sure you have not understood up till now. A lot of conveyancing speak will be in jargon, and they're going to use a lot of jargon when they speak to you, and often you're not going to understand what they're trying to say to you. So the first thing we're going to do is to understand the essential requirements and procedures that a conveyancer takes part in when registering transfer of ownership of immovable property. Now, we know that registration of transfer of ownership is such an important facet of the estate agency function, because unless the transfer is registered, you're not going to get paid your commission. So I know you go banging on the doors of the conveyancer to find out why is it taking so long and what's happening and what's going on, why are we not getting our commission. So we're going to have a look at some of the intricacies of the conveyancing process, just so that you realize what an important fellow or lady that conveyancer actually is. As I said, a lot of the jargon that will be used needs some explanation. I'm not going to go through it entirely with you. It's on the slide. Have a look. So, terms that are used are attachment. You know what an attachment is. It's a formal act executed by the sheriff in terms of a court order in which a property is attached. And what that means is you can no longer transfer that property until the attachment has been removed. Then we come across a thing like a caveat. A caveat is also a registration against the property which prohibits that property from being dealt with or transferred. So it's something that has to be removed first before we can do so. Other things are cession. I'm not going to go into that. Contractual capacity. You all know that that a document. You all know that a person must have contractual capacity to enter into a legal agreement of sale. If they don't have contractual capacity, that sale agreement is not going to be valid. I think, for example, of, let's say, unrehabilitated insolvent. To all intents and purposes, that person might seem to have contractual capacity and may not have disclosed that they are unrehabilitated insolvent, and suddenly you find out when you're getting to the transfer stage that you can't proceed with the transfer. Deed of transfer, you all know what that is. That is the document that evidences title. And in our system, which is a fantastic system, you're able to rely implicitly on that deed of transfer to know that the property concerned is owned by the person who the document says owns it. In many other jurisdictions, and one thinks, for example, of Australia, America, other countries, you're never sure, even when you have a deed of transfer, that the person who says that they own the property actually owns that property. In many of those countries, people actually take out insurance to confirm that they are the owner of the property, in case somebody with better title will approach them later and find out that you are not in fact the owner, but someone else owns it. That fortunately cannot and does not happen in South Africa. We have an endorsement. An endorsement is an official stamp. If you've had a look at a deed of transfer, you'll see one of the prime endorsements is an endorsement which shows that there's a bond registered over the property. That is a stamp that's placed on the deed of sale, which shows that there's a bond registered, and it shows you what the number of that bond is. So if you want to, you can then have a look at that mortgage bond and see what the position regarding that bond is. General plan is something else. Legal capacity. Lodgement, we're going to deal with lodgement, but lodgement is the formal process by which a conveyancer hands the documents into the deeds office for registration. When you phone a conveyancer, sometimes you're going to be told the document is ready for lodgement. Now you'll know what that means. That means that everything has been done and the conveyancer is ready to lodge that document at the deeds office. Municipal clearance, I'm going to talk to you about a little later. Personal servitude, I'm going to talk to you about a little later. Power of attorney to pass transfer. Now, you know, anybody can actually appear personally before the registrar of deeds and pass transfer, but it's something that we don't like to do because it's scary and we don't know what's expected of us. So what we normally do is we give that conveyancer a special power to pass transfer in our name. So if I'm selling the property, I will give the conveyancer a special power of attorney to act on my behalf and to register the transfer of the property. Prodial servitude, we're going to talk about. Title deed, I think we know. Transferee, we know. Transferor, we know. But if you don't, have a look at the slide and you'll get a definition of what these terms refer to. Now, often you're going to find in the conveyancing parlance, they're going to talk about a real right or a personal right. Now, when we come to property and ownership of property, you'll find that they will refer to a real right in property. That means that you as the owner have the right to use the property, you have the right to the proceeds of the property in the event that you should sell the property, and you even have the right, if you're stupid enough to do so, to destroy the property. You can abuse the property, you can actually do anything that you like with the property. So your right is a real right. Nobody can tell you what not to do with the property. But there are certain legal restrictions pertaining to that property which limits that real right that you have. So eventually, we're not going to talk about a real right in property, but we're going to talk about a limited real right in property. So you have this real right, but it's limited. And how is it limited? It can be limited by regulation, it can be limited by legislation, it can be limited by zoning. There are a whole way and gamut of means by which a real right can be limited. For example, you have the right to the use of that property, but your neighbor has the right to the use of the neighbor's property. And your use of your property may not interfere with the use by the neighbor of the neighbor's property. So your real right is again limited. Now, we also draw a distinction between real and personal rights. A real right is a right that is capable of registration in the deeds office, whereas a personal right is one that is not capable of registration in the deeds office. So what is a real right then? A real right, and remember we've referred to your right to property as a real right. A real right in property is one that is enforceable against the entire world. That is your right. You own the property. No one can come and evict you from the property without good cause or without a court order to do so. So it's a real right. A personal right, on the other hand, is a right that is not enforceable against the whole world, but only enforceable against another person. This might be, for example, a personal servitude, where a person has the right of use of your property. That right of use is a personal right, and it's not a right that is enforceable against the whole world. So remember that. Now, in terms of the Deeds Act, the Deeds Registries Act, the Registrar of Deed is in fact required to register, transfer, modify, cancel real rights in property and also servitudes. The general test in determining whether a right is a real right or is a personal right is, will that right diminish or restrict the right of ownership? If it does diminish or restrict the right of ownership, it will be a real right. So ownership will be diminished by granting rights that generally form part of the ownership right, or by placing restrictions on the exercise by the owner of the property of his ownership rights. Personal rights may, under certain circumstances, be registered. For example, a personal servitude will be registered, but it will only be registered if it is ancillary or complementary to another registrable condition, or if it forms part of a mortgage bond or a lease. So under certain circumstances, a personal right will be registered, but these are very narrowly transcribed in terms of the Deeds Registries Act. Now, conveyancer, this person that actually takes over and runs the transfer of the property. We all stand in awe of conveyancers because a conveyancer is a qualified attorney. Only qualified attorneys can actually become conveyancers, and they are admitted as conveyancers by the High Court. In other words, we presuppose that having been admitted by a High Court, and some conveyancers have let us down, but I would say the great overwhelming majority of conveyancers are honest, impartial, and will act in the interest of truth and justice. Therefore, a conveyancer is a person that you can absolutely rely upon. And it is for this reason that the Deeds Registries Act and Regulation places certain onerous conditions upon conveyancers. They're required to do a number of things when it comes to the registration of an immovable property. And there is a great duty of care and skill attaching to a conveyancer. So I hope once we've proceeded with this presentation, you'll more fully appreciate just what a conveyancer is and what that person does. Each registrar of deeds keeps a register of admitted conveyancers, because only admitted conveyancers are able to prepare certain documents and, generally speaking, be given a special power to pass a transfer to appear before a registrar of deeds to execute deeds and to prepare deeds for registration. Now, when we talk about the activities of a conveyancer, you will see that they have a large number of activities, they have a large number of functions, they have a large number of duties. They have a really onerous checking function. They need to ensure that everything is in order before they lodge a title deed for registration in the deeds office or any other document in the deeds office for registration purposes. When it comes to the question of purchase and sale, the major function of the conveyancer is to ensure that the sale agreement is a valid agreement. Once they receive a sale agreement from an estate agent, they will have to satisfy themselves that a valid sale was actually concluded and that the transfer of the property can be proceeded with. It's for this reason that you will often receive a query from a conveyancer once the paperwork has been handed to that conveyancer to start the transfer process. They will query certain conditions in the sale agreement. They will query the capacity of persons to conclude the sale agreement. They will query a whole number of things. Clauses might, for example, be unclear. They are not sure about the finances that are required to finance the transaction, and they will then come back to you and find out what is the reason underlying this transaction. It may sometimes be necessary for a conveyancer, in fact, to have an agreement re-signed because the person signing it may not have done so properly. There will be a whole number of facets that the conveyancer will attend to and come back to the estate agent and query. What do they do then? They manage the financial matters and the transaction process. As we know, with the sale agreement, there are many financial aspects that need to be attended to. There is a payment of money. A buyer is going to pay the seller money to effect transfer of the property into the name of that buyer. So it is up to the conveyancer efficiently and effectively to manage the financial matters consequent upon the sale of a immovable property. Then having satisfied themselves as to these two aspects, they need to prepare the required deeds and documents, and they have to take responsibility for the correctness of all facts. This is very important. I'm going to repeat it. It is the conveyancer who takes responsibility for the correctness of all facts. If something is incorrect and the conveyancer, by signing that agreement, certifies that it is correct, that conveyancer is for the high jump. So a conveyancer will check very carefully all the facts that are required to be proven and are required to be known before agreeing to proceed with the transfer. So all documents are thoroughly checked, and the conveyancer cannot delegate this duty to the secretary that he uses. If the secretary misses something, it is the conveyancer's responsibility. So by signing the preparation clause that appears on the top right-hand corner of the deed of transfer, the conveyancer is actually accepting full responsibility for the correctness of those documents and confirming that the deeds have actually been prepared by that conveyancer. The deeds office, in terms of the regulations, is entitled to accept the correctness of those facts as signed for by the conveyancer. So it is unnecessary to prove such things as, for example, the correctness of identity numbers. If a conveyancer has taken your identity number and included it in the deed of transfer, the deeds office is not going to query that. Should it later transpire that that identity number is not a correct number, it is the conveyancer who has to bear all the consequences. Finally, the conveyancer liaises with affected parties to the transaction to ensure that the transaction goes smoothly and that everything is done as is necessary. Now we're going to have a look at this liaison function to show you exactly what a conveyancer does in their daily life at the office. The conveyancer will liaise with the seller. And what will they liaise with the seller? They will have to ascertain such things as the marital status of the seller. Is the seller married? Is the seller single? Is the seller, if married, married in community of property? Married out of community of property? These things are very important because they will affect the transfer process. If the seller is married out of community of property, it will be necessary for the conveyancer to obtain a copy of the ante-nuptial contract that has been registered at the deeds office, evidencing the fact that such marriage is one out of community of property. The conveyancer for the seller needs to obtain a copy of the existing title deed in the name of the seller, because that is a document that will have to be lodged at the deeds office. He will have to obtain the electrical compliance certificate. Other things that will have to be obtained are documents that might be required by the deeds office, and we're going to have a look at those later. So there are a number of supporting documents that the conveyancer will want to look at or will have to draft and will have to have signed with the seller. Once he has drafted those required documents, the conveyancer will arrange for the seller as a transferor to sign all those documents and will ensure, and this is a primary function, ensure that all arrangements regarding finances affecting the transfer are in order before proceeding to transfer the property into the name of the purchaser. So having done all this, the conveyancer is now ready. What he does, arranges for lodgement, and we're going to have a look at that in due course, of the necessary documents in the deeds office, finally lodges the documents at the deeds office. What happens is that once the documents have been lodged, the documents then come up for what they call preparation. In other words, for the conveyancer to go again and check that everything is in order and to make minor rectifications. If any minor rectifications are required, at this point they can be done without in any way hindering the transfer process. Transfer is finally, hopefully, registered into the name of the transferee, who is the purchaser, and it is then up to the conveyancer to account to the seller in respect of the transaction. And what does that mean? The seller wants his money. So the conveyancer needs to account to the seller and account to other parties, as we're going to see. But that is not the end of it. The conveyancer also needs to liaise with the purchaser, the transferee, the person to whom the property is going to be transferred. Almost the same kind of list applies. The conveyancer must find out what the status of the purchaser is, whether the purchaser is married, if married, whether in community or out of community of property. Obtain a copy of the identity document of the purchaser. You've seen that the conveyancer is responsible for correctly inserting the correct identity number of the parties. So he will want to check carefully that he has the correct identity document. Important where the purchaser is concerned is a conveyancer will want full particularity regarding how this sale is going to be financed. He will have to obtain a whole variety of other documents and will have to obtain a payment by the purchaser of the costs of transfer. Like everything in life, to transfer a property is not a freebie. There are costs incurred, and the conveyancer needs to have these costs up front before proceeding with the transfer. The conveyancer, having obtained all these documents, checks the documents, prepares a draft deed of transfer into the name of the purchaser, and ensures that all the required supporting documents have been prepared and are signed once they are ready for signature by the purchaser or the transferee. The conveyancer, most importantly, ensures that all the financial arrangements pertaining to the transaction are in order, arranges for the lodgement of the documents in the deeds office, lodges the documents at the deeds office. When the transfer comes up for prep, as we've already talked about, does the final check to ensure that all the documents are in order, does the final check to ensure that the financial arrangements are in order, and then allows transfer to be registered into the name of the transferee. Now the conveyancer accounts to the purchaser in respect of the transaction. We've decided that the purchaser wants to get some money out of the transaction, so that's the money that the purchaser receives. And it is now incumbent upon the conveyancer also to advise the local authority of the details of the new owner of that property. In other words, the local authority needs to be informed that the prior owner is no longer owner of the property. It's been transferred in the deeds office, and details of the new owner are then given to the local authority, obviously for things like municipal services and who is going to account to the municipality for the payment of any municipal requirements and charges. Where the property, as is usually the case, that is being sold is subject to a mortgage bond, there's a further obligation upon the conveyancer now to liaise with the existing bondholder, because the transfer of that property to the new purchaser cannot be effected until the existing mortgage bond that we've seen has been registered over the property, and there will be an endorsement on the title deed to this effect, and there will be a registered mortgage bond, has been cancelled. So it's incumbent upon the conveyancer now to liaise with that bondholder with a view to cancelling that mortgage bond. So what the conveyancer does is he ascertains A, in whose favour the mortgage bond is registered, what the bond cancellation requirements are, and also requests the original title deed from the mortgage holder. What invariably happens is that if a property is subject to a mortgage bond, the owner of that property will not retain the original title deed, but the grantor of the mortgage finance will want to hold that title deed as a further security until either the bond is cancelled or transfer takes place and arrangements for the cancellation of the bond are always made. Almost all cases where a mortgage bond is registered over a property, it's not the owner of that property that will hold the original title deed, but in fact the mortgage holder will hold the deed. So the conveyancer will ask for two things from the mortgage bondholder. What are your cancellation figures? In other words, how much money must the seller pay to you to have that mortgage bond cancelled, and for the original deed of transfer registered in the name of the person who is now selling the property. So in due course, and this can take quite some time, remember the conveyancer is now at the mercy of the mortgage bondholder. Conveyancer will ask that person or that institution for the required cancellation figures and for the original title deed, and now has to wait and wait and wait until that information and that document arrives. So be kind to your conveyancer. Remember, the conveyancer is doing everything possible, and if there's a delay that is incurred at this stage of the proceedings, is probably not due to the conveyancer, but due to the mortgage bond holder. Eventually, the conveyancer, however, will receive the bond cancellation figures, will receive the original title deed, and will now be told who the conveyancer is who is going to attend to the cancellation on behalf of the mortgage bond holder. Sometimes it can be, and this facilitates the transfer process, that the conveyancer who is doing the transfer also attends to the bond cancellation. But frequently this is not the case, so you're going to have two conveyancers involved, one conveyancer attending to the transfer of the property, another conveyancer attending to the cancellation of the mortgage bond. And this, of course, means that the two conveyancers need to liaise closely with one another to ensure a smooth transaction. Now, what happens is that the conveyancer, having been informed of the amount that is necessary for the cancellation of the bond, then procures what we call a guarantee. We don't pay cash over. The conveyancer will then go to possibly the new bondholder, the bondholder from which the purchaser is going to obtain mortgage finance to finance the transaction, and will ask for a guarantee. What this guarantee is merely an undertaking by the new mortgage bondholder to say that once transfer is registered into the name of the purchaser, that institution will then pay to the conveyancing attorney the amount required to cancel the bond. So we arrange for the guarantees in favor of the mortgagee. Another thing we have to do is pay the cancellation costs, because to cancel a mortgage bond again incurs costs. So we will find out what those costs are and pay the bond cancellation costs to the bond cancellation conveyancers. Having done all this, and you can see it's quite a lengthy and protracted procedure, but most conveyancers are able to do this without too much delay, but again, sometimes are at the mercy of outside influences beyond their control. But having done so, they will now arrange for signature of the relevant documents. They will again ensure, and you'll find this coming up time and time again, that the financial arrangements are in order. The one thing you don't want to do is to either have a mortgage bond cancelled or to have a property transferred when financial arrangements are not in order, because then you are going to be in serious difficulties, and it's likely that the conveyancer will be personally responsible for any damages that might have been incurred as a result of this failure. We arrange for lodgement of the documents in the deeds office. Documents are lodged at the deeds office. Documents come up for preparation. I think we're used to that by now. And the mortgage bond is then cancelled. The guarantee is cashed. You'll take it to the institution that issued the guarantee. You'll cash it, and amounts due on the mortgage bond are then paid once the bond has been cancelled. Now, we've got to this point, but another thing that we have to bear in mind is that the purchaser is likely to be funding, in most cases, the purchase of that property through registration of a new mortgage bond over the property. So to take the simple case, you have a purchase and sale. The seller is going to want to transfer the property to the purchaser, and the seller is going to cancel an existing mortgage bond over the property. The purchaser wants to take transfer, and to take transfer, the purchaser needs mortgage finance and will have to register a new mortgage bond over the property that the purchaser is now acquiring. So what does the conveyancer have to do? The conveyancer now liaises with the proposed new bondholder. In other words, we have to liaise with the bondholder that is going to be granting mortgage finance to the purchaser of that property. So the conveyancer will receive a confirmation of the grant of bond finance to the purchaser to enable the purchaser to fund the purchase, and ascertains how much has been granted, what amount is in fact available to fund this whole transaction. The conveyancer will obtain details of all guarantees that may be required to settle the existing bond, and will then also be required to provide guarantees guaranteeing payment of the purchase price as soon as transfer of the property has been registered into the name of the purchaser. The conveyancer will furnish the proposed new bondholders with a copy of the draft deed of transfer that is going to be registered to enable the new bondholder conveyancers to draft the bond and to draft supporting documents. So you can see it's getting quite complicated now. And this is just a simple sale agreement, which is actually becoming more complicated than one would first have thought. Okay, so now we receive the required guarantees, we arrange for lodgements, we lodge at the deeds office, the new bond comes up for preparation, the new bond is registered, and now the finances are utilized to pay the purchase price to the seller after settling payment of the bond in favor of that was registered in favor of the property by the seller, and the estate agent's commission is now also paid. So obviously, as estate agents, this is the step that we want to achieve as soon as possible, because this is the step, once this has been accomplished, we are now going to receive our commission. So we're going to hassle that conveyancer to get to this step as soon as possible. We're not going to leave out SA Revenue Service. They want their chunk out of this transfer process as well. And what do they want? They want payment of transfer duty. So if the purchase price exceeds the sum of 900,000 Rand, transfer duty will be payable on the transaction, and SARS will want to ensure that provision is made for payment of that transfer duty before allowing the transaction to proceed. If you have a look at Section 2.1 of the Transfer Duty Act, it provides that transfer duty is payable on the value of property acquired by any person by way of a transaction or in any other manner, and the amount by which the value of any property is enhanced by the renunciation of an interest in or restriction upon the use or disposal of that property. I'm not going to worry so much about the second aspect, but the first aspect is more important in what we're doing today. They want to know what the value of the property acquired is. And SARS has the right, if the purchase price of the property is deemed to be insufficient to cover the value of the property, not to accept the purchase price as being the value of the property, and to stipulate rather the value of the property when it comes to the payment of transfer duty. Importantly, in terms of Section 12 of the Act, a property cannot be transferred until proof is produced to the Registrar of Deeds that the transfer duty has in fact been paid. So what does the conveyancer do? And fortunately, these days, everything is online, so it actually facilitates the payment of transfer duty. You apply to SARS for transfer duty and pays the transfer duty where relevant, receives a transfer duty receipt or an exemption certificate. As I say, if under 900,000 Rand, there will be no transfer duty paid, so you will receive a certificate from SARS that that transaction is exempt from transfer duty. You check the correctness of the transfer duty receipt or exemption certificate, and you then have to lodge that transfer duty receipt or exemption certificate at the time when all the other documents are lodged for registration. There we have the current transfer duty rates. one must bear in mind that these rates change annually with the passing of the budget. So while this is what the current rates are at the time that this session was recorded, you need to ensure that you keep abreast of what current transfer duty rates are, because they do change from time to time. Another thing that we also have to remember is that the local authority also wants its cut out of this transaction. In terms of the Local Government Municipal Systems Act, the transfer of property may not be registered unless the Registrar of Deeds is furnished with a certificate issued by the local authority in which it is certified that all amounts due to the local authority in respect of municipal service fees, property rates, municipal taxes, etc. have been paid. This is the famous clearance certificate that is required. The rates clearance certificate also must be valid for a period of 120 days. That is for 4 months from the date of issue. Now, a lot of sellers are going, when the conveyancer goes to the seller and says, I need money to pay for the rates clearance certificate, and you need to pay your rates for an additional 4 months, a lot of sellers say, why? It's a lot of money, and why should I have to pay it? The reason that you have to pay it is because the Local Government Municipal Systems Act says you have to pay it. So the conveyancer applies to the municipality for the rates clearance certificate, receives an estimated account to cover a period of 120 days, and pays the local authority and obtains that rates clearance certificate. That rates clearance certificate has to be lodged with the other documents that are lodged at the deeds office in order to enable the transfer to be registered. Often you're going to find that that the purchaser and seller have to sign what is called an insolvency affidavit. And a query often arises as to what is this insolvency affidavit. Remember, I told you right at the beginning that a person who has been sequestrated remains insolvent either until rehabilitated by a court or after the expiry of 10 years from the date of the insolvency order. Now, the Registrar of Deeds is advised of this insolvency and registers a caveat. Registers a caveat against that property. The caveat says that this property cannot be transferred until the insolvency question has been resolved. Now, what happens is that the registrar doesn't link the caveat to a particular property. If, for example, John Jones was then sequestrated, the Registrar of Deeds will register a caveat against every property registered in the name of John Jones because they're not able to register it against a particular property concerned. So it's become common practice for the owner of a property who is going to be transferring that property to show that they do have the capability, that they do have the authority to transfer their property by signing what we call the insolvency affidavit, in which it is confirmed before a Commission of Oaths that the seller has not been insolvent and has never was insolvent. And on the basis of this insolvency affidavit, the conveyancer can lodge the documents and show that any caveat that might be registered against a certain John Jones does not apply to this particular individual seller. So that is the insolvency affidavit. Other consents may also be required. If, for example, a person holds a usufruct, a personal servitude over a particular property, that property cannot be transferred unless the holder of the usufruct or the right of use of that property, which is a personal right, consents to the transfer of that property. So unless that consent is given, the Registrar of Deeds will not register the transfer. Now, remember, in the very simple case that we looked at, the simple transfer of a property upon the sale of that property could well involve at least 4 conveyancers. It could involve the conveyancers attending to the registration of the deed of transfer in the name of the purchaser. It could involve the conveyancer who is attending to the cancellation of the existing bond. It could involve the conveyancer who is attending to the registration of a new bond. And it sometimes happens that there could be more than one bond registered over a property, in which case you're going to have another conveyancer entering the scene. So what normally happens is that these deeds and these various documents must all be lodged together. And even though they are prepared by a different set of conveyancers. So by arrangements, these various deeds that are required to effect this quite simple transfer actually are linked as a batch by agreement between the various conveyancers. The various conveyancers will liaise with each other to determine when they are going to be lodging the various required documents at the deeds office. And they ensure through liaison that all the required documents are lodged in separate lodgement covers, because we're dealing with separate conveyancing firms, but on the same day. This doing so, linking the documents as a batch, enables the deeds office staff to check the batches and to simultaneously register the batches. In other words, what's going to happen in our simple example, the deed of transfer is going to be registered, the mortgage bond existing over the property is going to be cancelled, a new mortgage bond is going to be registered, and all these things must be done at the same time. The linked deeds are then deemed to have been registered only when the last act of registration of the batch has been signed by the Registrar of Deeds. Until the last deed has been signed, no registration will have been effected. Now, if one of the conveyancers in this chain fails for some reason to lodge the required documentation, you're going to find that the whole process is going to be delayed, because everything is going to be rejected and the conveyancers have to relodge again once they've made a further arrangement. Now, the duties of the conveyancer after the registration of deeds, and here we come to the important point of commission as well. The conveyancers advise their clients of the registration of various deeds. Guarantees and undertakings related to the various linked transactions are presented for payment and are honoured. The conveyancers account to their respective clients for monies received and debit their fees. And after the various deeds are returned to the respective lodging conveyancers by the deeds office, these are delivered by the conveyancers to their clients. This normally takes about a month after the registration, where the original documents are then returned by the deeds office to the conveyancers. Where there is a bond registered over the property, as we've been discussed, it is unlikely that the original deed will be given to the new owner of the property. More likely is that the original deed will be sent by the conveyancer to the mortgage bond holder. Old defunct deeds, such as the old cancelled mortgage bond, can be handed to the client or retained in the conveyancer's file. The previous bondholder really doesn't want the old mortgage bond. It's now been cancelled. It's of little use, little effect. So really nobody honestly really wants it. So you're going to find in most cases the conveyancer will retain that document. That's about as far as I'm going to take you when it comes to the registration process and the conveyancing process. You will see that there is a huge duty resting on conveyancers to ensure the facilitation of a smooth conveyancing process, and as and when problems arise, the conveyancers will be in touch with their clients and will seek to ensure and minimize these to the greatest extent possible to facilitate the smooth registration of transfer. I'm just going to touch on, because I don't think I have time to go any further than that, on the Spatial Planning and Land Use Management Act. This is an act which I believe that all estate agents should be aware of. Don't expect you to be an expert on SPLUMA as it's known, but we do expect you to have somewhere in the back of your mind knowledge that such an act exists. Because SPLUMA creates an overarching framework for spatial planning, for policy and land use management. It includes rural and informal settlements, and especially is linked to zoning schemes being at the heart of a whole new planning system. Now, what does SPLUMA do? It specifies the relationship between spatial planning, land use management, and other kinds of planning. It ensures that the system of spatial planning and land use management promotes healthy socio-economic inclusion as opposed to the exclusion of the past. This act now specifically provides for an inclusive spatial planning and land use management system, and provides for the establishment of social development principles and norms and standards for the sustainable and efficient use of land. Provides for cooperative government and intergovernmental relations amongst national, provincial and local spheres of government. This was something that was previously lacking, and when one wanted to rezone a property, or one wanted to do something involving spatial use and land planning, one normally would have to go to all three of these governmental spheres. That is now a thing of the past, so the whole system has been simplified. And most importantly, where SPLUMA is concerned, seeks to redress the imbalances of the past by ensuring equity in the application of spatial development planning and land use management systems. There are a number of definitions contained in the Splumer Act that one needs to know about. For example, what does land development mean? Land use management systems, township registers, townships, zones, spatial development framework, municipal planning tribunal, Minister of Rural Development and Land Reform. These are definitions that every estate agent should be aware of, and I can only suggest that you have a look at the Act and acquaint yourself with these definitions, because at some stage somebody is going to ask you about Splumer and what you know about Splumer and what is Splumer all about. The key development principles and norms and standards include such aspects as spatial justice, the creation of a municipal planning tribunal, spatial sustainability, efficiency, spatial resilience. These are all concepts that the Act has for the first time included in the land management environment that I think estate agents should at least know and be aware of, if not 100% understand. The spatial development framework means that municipalities are obliged to develop spatial planning regimes for the development and zoning of land. They must adopt and approve a single land use scheme for the entire area within 5 years from the date of the commencement of the Act, and this must promote economic growth, social inclusion, efficient land development, public health, environment, and natural resources. Land may only be used as permitted by a land use scheme, a town planning scheme. And the new thing is that land use schemes must be reviewed every 5 years. So we are no longer going to sit with obsolete and no longer relevant or valid land planning schemes or zoning requirements. Development applications must be submitted to a municipality, and municipal planning tribunals are established to determine land use and development applications. Conditional approval and application lapses if a condition is not complied with within a period of 5 years as from the date of the approval, and persons claiming to be interested persons in a land development application or an appeal are required to establish their status as interested persons. Consent in a title deed may be granted by a municipality. Remember, we spoke about what consents would be required. Splumer does provide for the granting of certain consents. This defines what an interested person is. An interested person, for the purposes of a Splumer appeal, is a person having a pecuniary or proprietary interest or able to demonstrate that that person will be adversely affected by a decision of the planning tribunal or an appeal in respect of that decision. There are various other general provisions, and I'm not going to go through those, but we would like it, and it would be great if estate agents, having been made aware of Splumer, of the importance of Splumer in the land planning and spatial environment, would make the time available simply to have a look at Splumer, Google Splumer. Professor Google is always good at explaining these concepts, and just be aware that it is something that may impact upon your activities as an estate agent. That brings me to the conclusion of the presentation. Please remember to answer the 10 multiple choice questions to obtain your 5 verifiable CPD points for this session. Thank you so much.